In this video, we would like to discuss about the last portion of talaq, and that is judicial divorce. And this judicial divorce, as its position in Quran, we would like to discuss about that. The Muslim law givers also provided for the dissolution of marriage by a decree of the court, and it is called farqat. So it is in traditional Islamic law, it is called farqat. Literally means separation. The Quranic verses on judicial divorce run thus as, and if you fear a breach between the husband and wife, send a judge out of his side and another from her family side. If they are desirous of agreement, God will effect reconciliation between them, for God is knowing and apprised of all. For the practical application of this injunction, the Prophet gives his views. According to Prophet Muhammad, as he said, let the case be referred to two Muslim arbitrators, free and just, once one chosen from the family of each of the parties, and they shall see whether in that particular case reconciliation or separation is desirable, and their decision shall be binding upon them both. And as Amir Ali says, that when the husband is guilty of conduct which makes the matrimonial life intolerable to the wife, or when he neglects to perform the duties which the Islamic law imposes on him as obligations resulting from marriage, or when he fails to fulfill the engagements voluntarily entered into at the time of the matrimonial contract, she has the right of preferring a complaint before the Qazi or judge and demanding a divorce from the court. So, now we'll discuss the various position of Indian courts regarding divorce before the Dissolution of Muslim Marriage Act 1939 was enacted. So, before that, in Indian courts, follow the Hanif doctrines and lay down that the woman has no right of divorce. Indian courts granted a decree of divorce to the wife only on two grounds, and that is one, lian, where the husband alleges of adultery regarding wife, and the second one, that is relating to apostasy. In the latter case, since apostasy of either spouse resulted in automatic dissolution of marriage, it was doubtful whether a decree of court was necessary, as would be evident. The Dissolution of Muslim Marriage Act 1939 contains certain fault grounds. So recently, by judicial interpretation, breakdown theory of divorce has been discovered in Muslim law. So, under the Dissolution of Muslim Marriage Act 1939, we found two different grounds of divorce of a nikah or Muslim marriage. One is the fault grounds of divorce, and by judicial interpretation, the breakdown theory of divorce has been discovered under the Islamic law. So, in our next video, we would like to discuss the fault grounds of divorce as provided under the Dissolution of Muslim Marriage Act 1939.